Good morning, everyone. My name is Deb Fuster. I'm the Director of Policy and Advocacy at the Victorian Council of Social Service, VCOSS, and I'd like to start by acknowledging the traditional owners of the land where I am today. So I'm at the VCOSS office in the heart of Melbourne, or Naarm, and I want to acknowledge the Wurundjeri people and pay respects to elders past and present, and to emerging leaders and any Aboriginal people with us on the call today. So welcome to another one of our Renters' Rights Rundown events, a really important part of our work around advancing rental fairness here in Victoria and making sure that the community sector is empowered with all the information that you need to be able to play your part in helping renters to assert their rights in the rental market. These events, as I mentioned, are for you, frontline community sector workers, to really learn about or refresh your memory on Victoria's renting rules, which are set out in the Residential Tenancies Act 1997. Many of you will know that there were more than 130 changes to the Act introduced in March 2021. And one of the really important features of that legislative change and development of at a strengthened regulatory environment is that there are stronger protections and provisions with people for disabilities. So today we're going to do a deep dive into those legal protections and regulatory protections in today's session. Firstly, we're going to have a look at what are the current provisions for people with disabilities under the RTA, under the Residential Tenancies Act, and also, I guess, what's out of scope as well. That's also important information for you in your practice. And secondly, how does the Residential Tenancies Act apply in practice? So thinking about the work that you do on the front line, when the rubber kind of hits the road, how do these kind of rights and protections come into play? So we'll talk through a few case study examples that illustrate how the Residential Tenancies Act is intended to protect the rights of renters with disability. I guess the key message from VCOSS's perspective is that no matter what part of the community services sector you work in, if you're engaging with a person with disability and they are a renter, we want to make sure that you've got the information that you need to in order to provide them with information about what their rights are, support them to assert their rights, and and to be able to, I guess, locate your practice in the broader housing justice ecosystem, and make sure that you've got really good information about where to refer people who are have a disability and are renting, where they can be referred to specialised supports where that's needed. So we have two guests with us today. We're really pleased to welcome and give you an opportunity to access their expertise. Firstly, we have Naomi Anderson, who's the Legal Practice Manager from Villamanta Disability Rights Legal Services. Naomi is going to take us through the disability tenancy rights and entitlements under the RTA and what the gaps are. Naomi is going to be followed by Bronwyn Trickett, who will be known to many of you as well as being involved with some of these Renters' Rights Rundown events previously. Bronwyn is a fantastic housing advocate from Action for More Independent Disability Accommodation, AMIDA. And Bronwyn is going to have, take a look at, what the application of rights are in practice, or not having the impact of not having rights met, what that looks like on the ground in terms of some, de-identified case study examples. Once these presentations conclude, we'll open up for audience Q&A, and you'll be able to ask speakers any question that you like around disability and renting. We've allocated plenty of time for this, so please make the most of it and have your burning questions answered. Before I throw to Naomi to start her presentation, I might just run through, if you haven't been part of one of these events before, how the Q&A session will work, because I'm sure that as Naomi is speaking, you'll have some questions that are already coming to mind for you, so you can start to be putting those in the Q&A box. So you can submit a question at any time through the Q&A box at the bottom of the Zoom window. We will moderate the questions because we expect that there might be some kind of common themes or common questions coming through. So where that's the case, we'll kind of aggregate those questions together. Just a note that the panel won't be able to answer questions about individuals or specific individual circumstances. It's really around, questions that kind of illustrate some of the kind of practice elements, rather than getting into a specific case that you're working on. We'll get through as many questions as possible. If we're not able to get to them all, we'll take unanswered questions on notice and we'll follow them up for you and communicate back to all people who are registered for this event with the answers to those questions. And just a heads up that we'll also ask you to do a quick exit survey that will pop up in your browser at the end of the event, so you can help shape future events that we run. So just want to thank you in advance for your input to that exit survey. So now let's get stuck in, and it's my pleasure to welcome Naomi from Villamanta. Thank you, Naomi.
Thank you, Deb. And I'd just like to echo what you said earlier about the importance of frontline workers helping people with disability reach out for support. I would say the one thing that Villamanta did notice with NDIS coming in was the number of calls we got in areas that we hadn't had queries about before, where a person with a disability was talking to a support worker, a health professional, support coordinator, and telling them something happening in their life, and that person would say, that doesn't seem right. Maybe we should ask about that. And most of the time they were on the money, and the person did have some rights that they could assert and were unaware of. So very much the frontline workers are the people who are able to assist in accessing those supports. I'll just share my presentation now. Right. A usual disclaimer, this information is training for information only and is not legal advice. If you do have questions about a specific circumstance, you should seek legal advice about that. We also acknowledge the traditional custodians of the land on which Villamanta works, the Wadawurrung people of the Kulin Nation, and pay our respects to elders past, present and emerging, and acknowledge all people with disabilities who continue to lead and inspire our work. A little bit about Villamanta. We're a free statewide community legal centre that focuses on disability-related justice issues. Our focus is the rights of people with cognitive impairment, and we operate specifically in some priority areas, although not exclusively. And they include guardianship and administration, disability-specific accommodation, disability service complaints, financial abuse, restrictive practice, NDIS appeals, and NDIS supports for people in closed settings. Right, to today, we will cover very quickly different types of accommodation, the laws that cover them, changes to the law, and questions. So the main types of disability accommodation we'll be talking about today are specialist disability accommodation, SRSs we'll talk about a little bit, and then we will spend some time on the concept of a SIL house. SDA, for those of you who've been working in the sector for a while, used to be called group homes under the state system, and primarily were housing people with intellectual disability in congregate settings. The difficulty with transitioning from group homes to SDA is that the old arrangements basically combined everything in an all-inclusive package run by the state. There was the accommodation, there was the supports, there was decision-making, there was often management of finances, all of which happened in that context of the group home and with the provider, and that provider quite often being DFFH. With the move to the NDIS and the separation out, the accommodation itself, or housing or tenancy itself, is separate to all of those other things. So the services are now funded by NDIS. The person has tenancy rights as a tenant. There were some rights previously, but it is now much clearer and separated in terms of those relationships. So now under the NDIS, there is a focus on people with high support needs and accessibility for SDA, with there being a range of categories of SDA, and rent is fixed at a % of Centrelink payments. So again, for those who were around back in the day, SDA includes those properties that were previously group homes, but also has been funded by the NDIS with the goal of making sure that there is more accessible accommodation available in public demand. So you're seeing houses like high physical supports where there's a lot of automation, a lot of accessibility built into the accommodation. The next option is a supported residential service, which has long been an accommodation of last resort and can have more than 30 residents in the one accommodation. SDA generally, the old style settings would have up to 6. Now the focus is on 4 or less. SRSs are run by private entities, and the payment that the individual makes to the SRS includes both rent and services, and often is at a very high rate, leaving very little residual from their pension. Which brings us to the third, which is a still house. Now, this is where a person has funding in their NDIS plan for supports, but needs a housing option in which to receive those supports. So SIL, supported independent living, is a form of funding to provide the supports that a person needs in their personal life, but also to get out into the community. But if you think about those personal supports, the assistance with meals, perhaps the assistance with household tasks, the assistance with personal hygiene and with getting up and getting ready for work in the morning, all of those types of assistance actually happen in the home. And how can you receive those supports if you don't have a home, or if the home that you're in is not appropriate for receiving those supports? For example, living with a family member who won't allow those supports into the home. So supported independent living providers have started offering a form of tenancy so that they can use the SIL funding that the participant has available. And those colloquially have become called a SIL house. So where do tenancy rights come from? The most important takeaway, if you only remember one thing from this session, is that people who are renting have tenancy rights. Way too often what we see is that people only approach us, and often for something else entirely, after the person has been moved on. Now, they weren't formally evicted. There was no process gone through. They just believed that they had to leave, and so they did. That's not the case. If they are a tenant, they have rights, and there is something that can be done, even if that something is delaying the process until they can find a better option. Delay can give so many better options and is the worst case scenario. The best case scenario is that the eviction can be avoided in entirety. So if you only remember one thing, please remember that one. Tenancy rights for SDA come from Part 12A of the Residential Tenancies Act. For SRSs, there is a separate act called the SRS Act, which has tenancy rights for those individuals. Still house, the still house came about, and we'll talk about it a little bit more in a moment, as a way of resolving a supports problem. And the tenancy rights have not been clear in relation to still houses because the Act didn't contemplate them, because they didn't really exist at the time that the changes were made. Okay, SDA, Part 12A, tenancy protections. So previously, group homes were covered under the Disability Act, under the state system, rather than the RTA. Difficulty with that, as I said, was that everything was provided together. The accommodation, the support, it was all rolled into one package. And there were very, very few people under those arrangements who asserted their tenancy rights. After all, quite often they were being provided that entire package by DFFH, and DFFH would simply move them to another property. And it seemed inevitable and not something that could be challenged. Quite often also, by the time that happened, the situation in the house was so bad that everybody agreed something needed to change. And it wasn't so much a question of tenancy rights as to this situation not working. But once we separated out tenancy and service provision, this went across to the Residential Tenancies Act that sits in Part 12A. The sections there were designed to mirror mainstream rights and duties of rental providers and rentals, with protections for residents against eviction and exploitation. But they offer additional protections, including safeguards against eviction and rent increases. So an example of that is that an SDA provider cannot give a resident a notice to vacate if the issues that are causing the notice to vacate are due to the disability, or they're due to a failure to provide supports, or they're due to subjection to abuse or neglect. Some of the other protections for SDA residents in the Act, as I just mentioned, enhanced protections about the circumstances that can lead to an eviction, acknowledging people's reliance on supports, an ability to challenge rent increases, an ability to have non-urgent repairs investigated and urgent, and protection against overcharging for utilities. So let's have a look at those one by one. Eviction when the supports have failed. So the theory is that robust STA is an NDIS category for people with behavioural responses related to their disability. So if a person isn't able to effectively verbalise if something is causing them distress, they may only have the option of a physical response, which potentially damages property. A behaviour support plan is likely in place to assist staff to recognise this distress and respond to it and deal with the issue, rather than allowing it to escalate to a physical response, which leads to the damage of the property. If the staff fail to follow the BSP and property damage occurs, the participant can't be evicted for that failure, because it's not them that has caused the property damage directly. It is a series of events commencing with staff not following the behaviour support plan that was given. The practice, however, is that by the time we even hear about this, most times the person has been relocated to an inappropriate setting and the provider is planning to withdraw services. So as I said, if you only take one thing away from today's session, it is that there are tenancy rights. The enhanced protections against eviction are great sitting in the RTA, but they only help if people actually know that they're there and are able to use them. More often than not, they don't know and they've been told you have to get out, and so they do. Challenging rent increases is also available under the Act. A difficulty being that the reasonable rent contribution is a % of pension plus some other amounts. If the rent increase is proportionate to the increases in Centrelink payments, it can't be challenged. So if the rent is increasing, but only to the same extent as the pension, that is something that can't be challenged under the Act. So the sort of things that we see: 6 residents sharing an average suburban property, which may include an office for staff. So they're pretty cramped in there. They're sharing bathrooms, they're sharing living spaces, and may well spend a lot of their time in their bedroom crowded with all their belongings because there's not a great deal of shared space, or they don't get along with their co-residents. Meanwhile, the property is ageing and the quality reduces every year, but the rent keeps slowly going up and up. If it's in line with the pension, there's no mechanism to challenge that, unfortunately. Presumably based on a concept of when you entered into the agreement, you freely entered into it, and if it's only going up at the same rate as the pension, then it's only going up the same rate as everything else is. However, people entering these agreements back in the day didn't have any other option. There was no other choice. And now, if they were to enter a new agreement, you wouldn't expect there to be that high in the number of residents. You wouldn't expect the house to be in that state of disrepair. So one of the gaps that we are seeing is that for people in group homes, the old group homes, there is not really a mechanism to challenge the fact that the repairs aren't really being kept up with and the rent is still going up. Non-urgent repairs. We tried this process recently and it was quite clear to us that Consumer Affairs had not had anybody use this provision before. CAB sent somebody out to investigate and the provider said, sure, we're onto it, we're doing something, which they've been saying for years now. CAB accepted that response as adequate so far. We're waiting to see what happens. So at this point in time, not particularly convinced that this really has teeth, but we'll wait and see. Overcharging of utilities. Likewise, we gave this one a try recently, and again, first time that CAB had anyone use this provision under the Act. So cost of utilities is shared between residents, and the SDA provider can't overcharge residents for utilities. Pardon me. But to request any action, the resident needs to be able to prove the overcharging. That's impossible when the provider refuses to give any details about utility costs. This then becomes useless for SDA residents. All right, still houses, SDA. At the heart of the problem is this disparity. The number of people receiving SDA funding under NDIS is on the left, and the number of people receiving SIL funding is on the right. Clearly, there is a massive gap between those who are receiving supports in their home and those who are funded for some sort of disability-specific accommodation. Now, not everybody with a disability needs disability specific accommodation. But there were going to be those who do and don't have access to it. So this new form of housing, SIL houses, sprung up since the NDIS funded people for SIL who don't have access to STA or an accommodation setting that is appropriate to receive the supports. People establishing these properties vary considerably, from well-meaning providers looking to solve a housing issue to criminal enterprises looking to access clients' SIL funding. The SIL funding packages can be in excess of $100,000, so it can be quite lucrative for providers. And as I said, not all of them are nefarious, but there are some who are absolutely taking advantage of vulnerable people. Now, because they're established to provide the service and the supports by people who didn't consider themselves landlords, the tenancy rights have been unclear. And many residents of SIL houses have agreements in place which do not acknowledge tenancy rights at all. You know, we see them send us through a document that says service agreement, and it talks all about the supports and then mentions in there, and you know, that you're paying this much in rent, which doesn't belong in a service agreement, but there's also no separate tenancy agreement. So the issues with that, tenancy rights were not recognised because the focus is on services. The SIL provider has a massive power imbalance with the tenant because they're holding tenancy rights at odds with the fact that they are providing support services. A very simple example of that is where the support worker actually reports something to the landlord that they have seen in the house. And that leads to the person being evicted. That wouldn't normally happen if you had a support worker in your house. They wouldn't be ringing up your landlord. But when they work for the same company, especially a very small company, that leakage of personal information can happen, and that person can be overstepping their role, but see themselves as somehow an agent of the landlord. Pardon me. The client then is often required to accept poor SIL service to avoid eviction. So if that SIL provider starts to get a bit slack, the supports they send turn up late, don't really do the job, there's constant problems, there's not much the client can do about that, because if they push the issue, they're afraid that they'll be evicted. And until recently, the law had no way of dealing with these situations. Okay, so the change is effective 1st of July this year. As you recall, SDA rights were quite clear. What they've done is change the definitions to bring SIL houses into this category and clarify their rights. Providers have 6 months from 1st of July to offer their tenants a choice of either an SDA tenancy or a standard tenancy. So clock has started. They are required to speak to their tenants and say, which one of these do you want? Which means they have to explicitly explain that they are considered tenants. This choice of tenancy agreement, they can have either an SDA residency agreement or a residential rental agreement. I won't go through the detail of these. They're in the slides and you will receive them after the presentation, but there are specific scenarios where one would be better than the other, and it will depend on the individual's personal circumstances. So, changes 1st of July. Is this the solution to the vexed issue of the SIL house? It's certainly a start. And we have represented some SIL residents in VCAT and resisted eviction every time, and that was under the old law. So I would expect that with the new law that VCAT will even have a clearer pathway to prevent people from being evicted where that is the issue. Problem being, that's a tiny minority. More often we hear what's happening after the person thinks they were legally evicted and they're now in a state of homelessness. A right you can't enforce is no right at all. And most SIL providers and residents have no idea what the law was previously, so they don't know that it's changed. For us, the most important matter is that significant education is needed to ensure SIL residents are aware of their tenancy rights. And I would actually say significant education is needed to ensure SIL providers understand tenancy rights, because as I said earlier, they're not all out there to rip people off. They're trying to solve a problem. by providing accommodation. But then when things get messy, they don't really understand their role as a tenancy, as a residential provider, and that the person that is living there is not just a client of their cell service, they're also a tenant. So watch this space, but more importantly, talk about this. Share this information with those that you're working with and talking to, because the more people understand that there are rights and that you can get help, the better for all. And on that note, I'll hand over to AMIDA.
Thank you, Naomi. It's a fantastic presentation. I really appreciate you sharing your expertise, a really informative start to the event. Really great to be unpacking with you what the Residential Tenancy Act means for people with a disability who rent and what gaps that they are. And I think, you know, it opens up a really great conversation with the many organisations and people on this call today around that really important kind of partnership between services such as yours, Naomi, and the disability advocacy sector and broader parts of the community sector in terms of really shining a light on what renters' rights are, some of those kind of disparities and gaps that can then inform our systemic advocacy as well. Before I introduce our next speaker, Bronwyn, a reminder that you can submit a question at any time through the Q&A box at the bottom of the Zoom window. We welcome your active participation in this session. So please use that Q&A function to ask any questions that are top of mind for you. Now, I'm really pleased to welcome our friend and colleague, Bronwyn from AMIDA. Thank you so much, Bronwyn.
Good morning. Thank you for having me. I'll share my screen with the slideshow that we're presenting today. So AMIDA is, the acronym is Action for More Independence and Dignity in Accommodation. And what we do, we support people with disability as valued members of our community. We recognise that people with disability contribute to and develop our community. AMIDA acknowledges that people with disability have a right of choice of where they live and who they live with. Further, people with disability have a right to good quality housing, which is accessible, affordable and non-institutional. People with disability have the right to live in the community and access supports to participate and have a good quality of life. Okay, so AMIDA is made up of a board of committee members who all have disability. We've been working in the community for over 3 decades. We advocate for tenants' rights of people with disability by standing up for people either individually or as a group, advocating for rights for people living in community residential units, which were what Naomi was referring to as group homes, working with other housing groups about rights for tenants with disability, speaking out for the rights of people in institutions, and there are still some institutions that are in the process of being closed down, I understand. AMIDA works towards better access for housing for people with disability. So these are the accommodation settings that are in the community at the moment. So this is a context. There's the choice of public or social housing, which have very long waiting lists that's government run. Some of those waiting lists are up to 20 years, even on a priority access application. There are supported residential services, as Naomi mentioned as well. There's residential aged care. There's short-term accommodation and accommodation that's used to provide respite or transitional accommodation, moving from one place to another. There's temporary crisis accommodation, although there is such a small amount. I think there were maybe 2 properties in Melbourne that were accessible and purpose-built for people with access needs. There's private rental, and there's homeowners with disability. Then what we're focusing on, what Naomi was talking about, is the specialist disability accommodation housing, which can be single occupancy, an apartment, somebody living on their own. It could be a shared living setting, enrolled with an SDA or enrolled with the NDIS as SDA in any other dwelling that provides permanent long-term accommodation where daily independent living support is provided. So some of those are funded by TAC, WorkCover, DFFH and the DSOA as well. What we are happy about with the changes with this legislation is that there will be more protections for people with disability. Some of the common advocacy issues that we see, people with disability with funding from the NDIS without a legal agreement for renting their home, left without rental protections available to the rest of the members of the community. The new agreements are now in place to ensure this scenario doesn't happen. So as Naomi was talking about, a lot of those SIL houses were nobody was given the option of having a rental agreement. People with disability who were renting and receive additional supports in their homes did not have protections under the Disability Act, who needed more than just the residential rental agreement. So we're talking about people here with perhaps behaviour support plans, who like Naomi was talking about, if they weren't being followed and the person was communicating in a physical way in a setting where perhaps there would be damage to property, those protections come in now. So the SDA agreements have those protections. People with disability who are renting NDIS funded housing, facing eviction and homelessness and not understanding why. So we would get inquiries through email or phone calls from people who were saying, I'm in this situation and I'm being evicted and I don't get it at all. So the new agreements need to be in a format that is accessible and understandable to residents. Another case example, there was a case where 10 residents were living in a rooming house setup and the clients had varying degrees of psychosocial disability. The needs and behaviours of residents were incompatible. We see this, we've had many examples of this kind of a setup. AMIDA's case was then unable to live in their home due to violence and antisocial behaviour from neighbours or other residents. These changes now mean that residents have a right to go to VCAT and have their human rights upheld, no longer stuck in a potentially violent or abusive setting without any mechanisms to change that or move out. More case examples. We have several cases where providers of SIL have set up housing where providing SIL support to a number of tenants without offering them a rental agreement, and we've touched on this already. And then clients were threatened with eviction when having issues arose. In one case, the provider then went to withdraw the supports of the housing, leaving the tenants in the home without a rental agreement. So that the SIL provider completely shut down, they withdrew their head residency, I guess. So they had taken out a head lease with his house and then they withdrew that. So the residents were left in a house with no SIL provider and no rental agreements at all. So providers will no longer be able to do this, and they must provide a legal agreement on either an SDA agreement or a rental agreement, as we've talked about. Some more examples. We've heard of multiple cases of providers overcharging when they notice an NDIS participant has a large budget in their plan, threatening eviction when a resident chooses not to use the rental provider support workers. So the person might move in and have both their rental living space and also using the support workers from the same organisation. The rental providers will not be able to threaten, intimidate or persuade a person not to exercise their rights. Renters now have protections and recourse if any of these present themselves. So I do recall we had a case reported that they were being asked to provide a large amount of money to secure their place in a tenancy if they were not going to use the support workers as well. If they were going to choose a different support provider to come in, have support workers come into the house and provide that daily support, and they were asked to provide a huge amount of money, and that wasn't appropriate. The next one, people with disability who want to live with their partner or family members can choose to take out a residential rental agreement and use their NDIS specialist disability accommodation funding for that. So this is something that was not very clear prior to the changes as well. And this allows family members and partners and people who are close to live in the setting without having to be in an SDA agreement. The potential impact of the changes. We want to see that every resident who receives funding from the NDIA for housing understand that they have protections. And Naomi was mentioning that as well, that's probably the most important thing to remember under the Residential Tenancies Agreement, and how to access assistance to use those protections. Every resident have their agreement in an accessible format. We want to see providers have more training on how to deliver accessible and easy read formats. Here's some more examples. Still providers renting a home to people with disability that is in disrepair or not accessible to the needs of the person with disability. Perhaps if their condition is progressive, they've been living in a setting where the house was accessible or apartment was accessible. Now their needs have changed and they have different needs. So through having an agreement in place, people will be able to request urgent and non-urgent repairs and request modifications with confidence that the requests will be documented, taken seriously and undertaken in a timely manner according to the Residential Tenancy Agreement. So that is something in the changes previously that came out a couple of years back, there were more rights for people to ask for modifications, and now there are even more. Still, providers who offer both accommodation and supports to people with disability will not be able to threaten eviction if a person chooses to employ a different provider to provide supports in the same accommodation. So as I touched on before, that other example, it's very clear that now that people can choose their own supports to come into the home. They don't have to choose the same support provider that the accommodation may provide. They can choose their own or people that they know, and have a sense of assurance that is not going to be something that will be asked of them to change support providers. It's very clear now. The impacts. Our hope is that rental providers will need to take into consideration the needs of each resident and the compatibility of each resident. Now they have access to more protections. That's really what we're looking for at AMIDA. So I'll hand back over to Deb now, having reached the end of the slides. And I think that we have question time coming up.
Fantastic. Thank you so much, Bronwyn. Really appreciate that presentation. Always really useful to have those case studies to really help us kind of grapple with quite complex, legal information as well. So a really great way of, I guess, breaking down barriers and ensuring that all community sector workers, including disability advocates, can, understand how to kind of support people with disabilities to know and understand and assert their rights. Your presentation really, I guess, drives home the impact of the Act on people with disabilities who rent. So now it's time for audience questions, and a reminder that you can submit a question at any time through the Q&A box at the bottom of the Zoom window. I'm going to ask, so Naomi and Bronwyn are going to be part of this Q&A session. So we've stopped the screen sharing in terms of the presentations, but Naomi's joined us back on screen, and I'll ask Bronwyn to come back on as well. Fantastic, thank you. So I can see, apologies if I'm turning my head. I've got multiple screens in front of me, so I'm going to just look across to the adjacent screen just to look at some of those questions coming through. And some of these will get really into some nitty-gritty as well, and recognising we've got experts on the line, but you know, sometimes we might need to, we'll be able to answer the question in real time, and sometimes we'll need to go back with just some follow-up information as well. So just want to provide that qualification for myself and for Naomi and Bronwyn as well. So one of the first questions is, and this is for both of you as well, someone is saying that they'd be interested to know what you think an accessible format for a rental agreement should look like. For example, someone with significant intellectual disability, and what are the ramifications for providers, rental providers, if they fail to provide an accessible version? So there's two questions there. What do you think an optimal kind of or acceptable, accessible format for a rental agreement should look like? And then what are the ramifications if a rental provider fails to provide an accessible version? Who'd like to go first with their thoughts on that? Naomi or Bronwyn? Bronwyn, over to you. Thank you.
Hi again. I'm happy to talk about that one. We haven't seen accessible versions made up yet, but what I do know, and in fact I have used this myself, the Consumer Affairs website have templates for rental agreements. So depending on what the needs of the person with disability are, that would need to be broken down into understandable. So, you know, whether the use of pictures or different language, provided that the rental agreement would have the law in there. You know, we're not changing it entirely to exclude the things that are the most important parts for the legal protections. Yeah, it would depend, and there are some apps available that do change difficult language into easy read. There are some apps available. I think it's called the Hemingway app. We shouldn't mention too many of these, but there are some available.
Thanks. Thank you, Bronwyn.
Sure.
Naomi, do you have some insights that you'd like to share, thoughts on these two questions?
I was just doing a quick search on the Consumer Affairs website to see if they have an easy read version, which at the moment appears they don't. So maybe that's something we need to do some joint advocacy on, because I really don't see providers having the resources to do an easy read of these documents one by one. This seems to be something that, given that there is a template for the agreements themselves, it seems to be something that could be put out there by Consumer Affairs so that the work is done in terms of translating it to easy read. But in terms of the question of somebody with quite significant intellectual disability being able to understand this agreement, the problem is not so much at the point of signing. The legal enforceability of it is what is of interest to us as lawyers. It's about, if the person hasn't understood it, then they can't be forced to comply with anything in it that is onerous. There are standard terms and conditions that apply to everybody, but if something else has been added in there, that's not going to be enforceable if the person couldn't understand it. It also will be going to what are the standard agreements. So they can't be just putting things in because the person doesn't understand it. And the most important thing for the person to take away from that agreement is, if things become problematic, that they have the right to request help, and that some things can actually go to VCAT so that there is a decision made about who's in the right and who's in the wrong. And the only other thing I would add is that if somebody has a quite significant intellectual disability and is subject to an administration order, it's going to be the administrator who is determining whether these rights need to be enforced, because they're the ones who have committed to paying the rent. So there's always other options of how those legal rights can be, you can find a way for enforceability of those rights. But ideally, you would have an agreement that the person understands. That said, has anyone here who is a tenant read every single word of their own tenancy agreement? Have any of you read every word of the last agreement you signed online? None of us do. We just want to get to the end and get the thing. The point of the agreement is that when things go wrong, you've got something to prove what was agreed between the parties, and the person living there is enough to suggest that they agreed to living there. But if terms are in there that are more onerous than what is in the Act, then they're not going to be upheld because the person didn't understand them.
It's Deb speaking, and I think Naomi makes some really great kind of reflections and observations there around having some capacity in our community sector, working with Villamanta, for example, as kind of the CLC with, expertise in this area with AMIDA, with the expertise that you bring as well to actually find the space to actually identify where there are systemic issues and do that advocacy. And I'm wondering, for example, Naomi, has any of this been tested, for example, before at VCAT? Because I think this is an important kind of part of really shining a light on some of the systemic kind of inequities and the discrimination that people are experiencing in different parts of the rental market, and kind of lifting that up and seeking and driving kind of improvement both through behaviour change, excellence in terms of resources, and that kind of whole advocacy kind of an improvement ecosystem.
So far, so very, very few matters make it to VCAT, and that's the sad thing. The ones that have, VCAT has upheld the tenants' rights every time we've been. But, I did have Intech come and discuss stats with me this morning, and they said, to their shock, they'd had a look through at all of the accommodation matters we've dealt with in the last 12 months, and they had a 50% withdrawal rate, meaning that 50% of the people who came to us to ask for help with an accommodation issue never actually saw the matter through. And I would say the main reason for that, in my experience, is something was going wrong. They were concerned, they thought to make initial inquiries, but then it all moved so quickly and everything turned upside down that they couldn't actually see it through. In fact, if we had been able to jump in earlier, if they had support to request assistance earlier, we potentially could have prevented the whole thing from happening. But once you're homeless and you're trying to get supports to come to a hotel room or to wherever, the last thing you have time for is calling the lawyer back when they're trying to contact you. So the way of getting to VCAT is to get onto these issues just that little bit earlier before things go horribly wrong.
Thank you. Really great advice, Naomi. It's Deb speaking again. Just in terms of residential agreements as well, question from the audience: if a resident is not in a position to sign off on a residential agreement and there's no appropriate support to affect that kind of signing or execution, what protections does the person have with the agreement? What kind of happens in that scenario?
Similar to what we just discussed, really, that there will be an implied acceptance of the agreement to the extent that it contains standard provisions.
Oh, I'm not sure if Naomi has frozen on the screen. Apologies. Naomi's frozen.
Is unlikely to be enforceable because I didn't understand.
Sorry, Naomi, it's Deb speaking. You temporarily froze. I'm wondering if you wouldn't mind just repeating the last couple of points that you made. I'm so sorry.
No worries. If it happens again, let me know. My internet connection's been cutting in and out this morning, which is not great. Effectively, it will be an implied acceptance of the agreement given the person is living there, but only to the extent of the standard terms and provisions. Anything above that, especially anything that has negative connotations for the resident, is unlikely to be enforceable because they didn't understand and agree to it.
It's Deb speaking. Thank you so much for that. Next question, it's just seeking some clarification around SDA and SIL, supported independent living. The question is, can you please briefly clarify, did people previously living in SDA and SIL, were they previously on a service agreement as opposed to a residential tenancy agreement?
I think I must have cut out again in the middle there because I lost you.
Thank you. It's Deb.
I can step in.
Bronwyn, thank you.
Yeah, that's okay. What
if I'm
understand.
going off track, just jump in and let me know. Go, Bronwyn.
It's cutting in and out a little bit. Well, I was going to say, I'm not sure about every, across the board, every example of this, but I do know that quite a lot of people had sort of no tenancy agreement at all. It was not really captured in a legal way. I'm not sure if you want to comment on that further, Naomi.
Thanks, Bron. So tenancy and service are completely separate now. They would have to have a service agreement for the provider to be paid for those services, or at least some sort of implied service agreement. The thing that was missing was the tenancy. What the changes have done 1st of July is say that effectively, if somebody is living in a place in order to receive those services, they are a tenant. And the provider must give them the option of whether they have just your standard tenancy agreement as you would for any other property in Victoria, or whether it's an STA agreement. So the law is now saying, looping that service provision in as a factor, that if that is why you are living there, that the provider then has to give you those tenancy rights.
Thank you. It's Deb speaking. Question here is, are residents or renters given a choice between Part 12A agreements and residential rental agreements? I'm interested to know if the residential rental agreements have less protections regarding notices to vacate. Is that one you're able to take, Bronwyn? Yep.
Yes, they absolutely do have less protections in the rental agreement. So if there are people that need, extra protections, say for example, there's property that's damaged and the rental provider wants to evict them, that they can't necessarily do that. If they're behind on their rent, I think that's rent arrears is included in that there are more, there's more leeway there for time for the rent arrears to be cleared. I think Naomi could probably talk more about the specific changes. I'm not sure if you want to comment more on that, Naomi, but I do know that there are quite a lot of extra protections under the law for SDA agreements than there are for rental agreements.
It's Deb speaking, Naomi. I'm not sure if you can hear us or if you're frozen. Are you in a position to comment on that? You might be frozen. We might just go to the next question, and Naomi can loop back with any additional commentary in coming moments as well.
We can certainly provide a list of the changes. What's the difference between an SDA and
My
a
internet is cutting out so much that I think it'll be.
We can certainly provide a list of those, with the material that people will be receiving from today's session.
Thank you. And this is the joy of being in the online environment. I think we're all well used to it now in 2024. So understand the challenges that you're labouring under, Naomi. And, we are a collaborative team here. So it's great that we've also got our colleague Bronwyn on the call. So in those instances where you're freezing, we're lucky to kind of have the expertise of Bronwyn as well. So and as Naomi has just kind of mentioned, I'm not sure if people have seen it in the chat, but I might just mention the fact, just to reinforce Bronwyn's point, that Naomi has also said that, as Bronwyn's mentioned, that that Villamanta can follow up with some written information post this session as well, just to go a little bit deeper into responding to that question. So thank you, Bronwyn, and thank you, Naomi. I'm just looking to the next lot of questions. So there is a question here around, is there a specialist advocacy support program that people in the audience can refer clients to that have disabilities? For example, ATAR workers for Aboriginal people or the Tenancy Plus programs. Is there anything that you can kind of advise, Bronwyn, in terms of AMIDA's role, what we know of Villamanta's role, but about that broader kind of ecosystem of like expertise and support that is available to people who are working in the sector, whether it's disability advocacy or other parts of community services that are supporting renters who have disabilities?
So AMIDA, we have, we are a small organisation. We have probably 1.2 full-time staff members for the whole of Victoria. So we don't have a lot of resources, but we work very closely. We do pick up cases, and we do also give advice and information on the phone. And we also do work very closely with Tenancy Victoria, who now are seeing a lot more of this kind of these kinds of examples where, you know, the protections weren't able to be brought forward before, and now they are. So they're definitely an organisation that we work together with very closely. We also work with Consumer Affairs Victoria, so they do give advice on the line, and they have a lot of information on their websites. So it's good to check. If you have a question, have a look at the Consumer Affairs Victoria webpage. If you can't be answered, give them a call. But certainly, and Villamanta as well, we work quite closely with Villamanta on these types of SDA issues. So you can always call around and get some advice on the line at least, even if the case cannot be taken up immediately.
Thanks, Bronwyn. It's Deb speaking again. And I think just that kind of I might kind of just segue for a moment just to say that, you know, Bronwyn, in terms of locating your presentation and AMIDA's expertise as well, you know, one of the kind of, I guess, key messages that you were saying from AMIDA's perspective is that, you know, you really want to ensure that anyone who receives funding from the NDIA for housing understands that they have like tenancy rights. And so that's a really kind of core focus for you. And then I guess if we kind of like lift that up and out as well, I guess what this is kind of located in is a broader, you know, Victorian agenda around rental fairness for all renters, including renters with disabilities. So thinking about, you know, joining the dots with, you know, Family Violence Royal Commission, the Disability Royal Commission really kind of shone a spotlight on the prevalence and impact of gendered violence on people with disabilities. And we know that that's actually Family Violence Royal Commission in Victoria has like driven a lot of kind of the changes to the Residential Tenancies Act that were made in 2021. And so just thinking about, you know, those new protections that exist now for victim survivors of family violence. And so that's where, you know, as workers, familiarising ourselves with those kind of, well, the issue, the prevalence of these issues and the protections that are available under the RTA for all victim survivors of family violence, and thinking about, you know, the information, expertise and resources that colleagues such as Tenants Victoria, Justice Connect, etc., can actually also support you with. And we'll also just include, you know, a link to some other resources that VCOSS has around family violence and renting as well, because we need to be thinking about this. And obviously we are thinking about this in the context of people with disabilities who are renters. Great to see you again online, Naomi, and thanks for bearing with us with your technical issues. We were just talking about access to kind of information and specialised resources for people working in the sector. One attendee mentions that they noticed SRSs have shifted about in the legislation. And I'm just wondering, Bronwyn, if we might throw to you in the first instance, if you're able to comment a bit more about what's happening in the SRS space. You know, is it the intention to move more people under the SDA framework? Is there any thoughts or reflections that you've got on that you could share with us, please?
We have a lot of questions from people about what's going on with SRSs at the moment, supported residential services. So this setting is, historically I understand, is the setting that has probably the most, the least amount of protection. So we've seen quite a lot of residents living in an SRS that have perhaps not been happy with one thing or another and haven't had the mechanisms to take those to VCAT or that sort of thing. There is a separate SRS Act, so it's not under these changes where SIL providers are now being asked to offer an SDA agreement or a rental agreement. It's not the same for SRSs, I understand. I have heard from one of our advisors that SRSs are in the they're going to be phased out but I have not seen any kind of starting of that yet. And I hope that there will be more protections for people living in SRSs, because we do find that sometimes this is like the provider of last resort, where people are trying to move from one place to another. Perhaps they're trying to secure SDA funding in their plans, or they're not happy with another home that they've moved into, and they move into an SRS and they find that it's quite different. So yes, it's a very important topic. We can provide some information on that too.
It's Deb speaking. Thank you so much, Bronwyn, and thank you. I know that you're doing a lot of heavy lifting with answering the questions at the moment. We really appreciate it, and we have a lot of empathy for Naomi with technical issues at her end, and I know that she'll join us as soon as she can. There's a question just around SIL houses. If a provider of a SIL house doesn't give a resident an option between a rental agreement or SDA agreement, is there one agreement that's defaulted to in this situation, Bronwyn? Oh, sorry, you're on mute, Bronwyn.
That's a really good question, and I'm not sure. I will need to get back to you guys with the answer to that question. Previously, what Naomi was discussing before, where agreements can be implied. This is we've seen that with verbal agreements or that sort of thing. But whether one defaults to the SDA or the rental agreement, I don't know. So I'll get back to you with that question, the answer to that.
Thank you so much, and you are such a wealth of knowledge, and we don't expect you to be able to answer all of these kind of spontaneous questions necessarily on the spot, Bronwyn. So it would be great that we'll kind of follow up for people with a bit more information as well. I'm just wondering if I could, you were talking about just, kind of mentioned, through this presentation, various kind of like safeguards, legal safeguards, et cetera, the role of disability advocates in this kind of ecosystem around ensuring that people know their rights, can assert their rights, and safely do so as well, because we know that there's a lot of kind of like fear about like repercussions. People are sometimes so scared about, losing their housing, and so the important kind of role that workers in our sector play to give people that confidence and safety to assert those very important rights. Really interested to talk about the community visitors scheme, like in this kind of ecosystem as well, and understand that part of the changes to the RTA, et cetera, mean that community visitors can visit more people living in specialist disability accommodation. From your perspective, are there also other opportunities that the community visitors scheme can assist in improving the rental rights of people with disabilities? Do you have any thoughts on that, Bronwyn?
Sure. Personally, I think the community visitors program is fantastic, and I'm really glad to see that there are more opportunities for community visitors to now visit unannounced and check on how things are really going on the ground. People can ring up the Office of the Public Advocate advice line and speak to OPA about the Office of the Public Advocate about the need for community visitors to perhaps visit a particular residence. That's always a way that can be communicated, that there's a need for that sort of somebody to check in. And I also noticed, while I've been doing the housing advocacy, there has been a change between dealing with general advocacy and housing advocacy. When we're talking about people who are in their homes, and Naomi mentioned this before, that a lot of people did not follow through on their VCAT application. Sometimes the risk of retribution from whoever they feel that they might be threatened by in that housing can really affect whether a person wants to use their rights or not. And, OPA also have a lot of resources that people can call up and access about abuse, neglect, violence, as we know, from the Disability Royal Commission results that we've seen recently. So do bear in mind that people in their housing will be particularly cautious around exercising their rights and may need a lot of reassurance, and the information is out there. It's a matter of just calling up and finding out exactly what you need to know and helping that person if you're in a role of assisting people in their housing.
It's Deb speaking. Thank you so much. And again, you know, I really kind of want to emphasize as well, like the important role that we all play in kind of working together, you know, in terms of, you know, that kind of what wraps around the individual advocacy, which is so important, that work that you all do, but that we kind of lift this up and in terms of like systemic advocacy as well, so that, you know, we can affect kind of like, you know, behaviour change, culture change, practice change, and also where there are kind of these, you know, gaps or weaknesses in existing legislation and regulation, that we can be really naming that up, providing some evidence around that, and pushing for that kind of next wave of reform as well, so that we're really ensuring that people with disabilities who are renting, no matter what kind of like setting that's in, have the strongest possible rights in place. And that they're really meaningful in terms of, you know, the exercise of those rights, the ability to exercise those rights as well. And just on that, there's a question here around further education that's needed to ensure that CIL residents are aware of their tenancy rights. And we're talking about that like in a strengths-based approach to say this can be really overwhelming, understanding for all of us working in the sector, for renters to actually understand what their rights are, the different kind of nuances in terms of how those rights play out in different types of settings, whether that's SDA, whether that's CIL, etc. And then the broader kind of context about what it looks like in the private rental market more kind of broadly. So just thinking about further education to ensure CIL residents are aware of their tenancy rights. Bronwyn, I guess just an invitation to get your thoughts about what do you think would be some effective ways to increase public awareness, providers' awareness around these tenancy rights, and just noting Naomi's earlier comments around, you know, gaps in provider knowledge, that sometimes, you know, there's really intentional kind of overt, you know, terrible behaviour by providers. And other times there are good kind of faith actors, good faith providers who just don't have the information, so they don't even know that they're, you know, not kind of doing the right thing or not compliant. Do you have any thoughts on that about increasing education and awareness?
Yes, yes, I do. In fact, it's something that we have in our systemic work, papers that we've written in the past, we have talked about quite a lot, not just in this particular setting, but across the board. You know, education for people who are working with people with disabilities in the housing industry, who might usually not deal with people with disabilities on a daily basis, that need to understand what needs and what skills to provide when presented with different cases and different scenarios. So, you know, I think that it would be really beneficial for providers of SDA to have some kind of information packs for people when they're receiving their SDA agreement or rental agreement around those rights. That would be ideal. I don't know whether that's going to be provided or happening. Also, as we mentioned earlier, the Consumer Affairs website have some templates for things. Perhaps those could be developed further to include, as Naomi mentioned, easy read. So they're ready for people to just access easily. So, you know, I'm not sure whether any other organisations that are dealing with these changes are going to be providing any kind of fact sheets or handy tips for people who are residents or people who are supporting them. I'm not sure. That would be great if we could see that. So perhaps it's something that we can look into and get back to as well about what providers might be providing what material.
Thanks so much. It's Deb speaking. And, I think a kind of clear message, from your work, Bronwyn, and your messages today is that we want to really, education is an example of like the work that we want to do to prevent breaches of people's rights in the first place, but also ensure kind of access to kind of early help, early advice, early intervention targeted both to providers, but also to workers in our sector who are, advocating alongside with people with disabilities, and renters themselves, so that we're kind of disrupting kind of or intervening early, in terms of any kind of emerging issues and resolving those, so that we're achieving housing justice for renters with disabilities. But just kind of going back to like when we get to that kind of pointy end where for whatever reason, kind of that education, engagement, advocacy has not kind of had that desired effect. And there's something that really should be kind of escalated and to VCAT for resolution and for remedy and for housing justice. Just thinking about, what Naomi was kind of referring earlier to the fact that a lot of cases that could be tested at VCAT and remedy affected at VCAT just don't get to VCAT for a number of reasons. People don't, feel that they can kind of proceed to VCAT. Other things kind of happen that get in the way. What do you think people with disability need to hear to encourage them to go through VCAT processes? And what do you think needs to be done to ensure that they feel safer to exercise their rights? Do you have any thoughts on that, Bronwyn, that you could share with us, please?
I do. Yeah, sure. So I know that VCAT have disability liaison officers who work with residents directly. So there is help actually at VCAT. There is also, the advocacy agencies available to us may be able to provide people with some reassurance if residents or even support workers are calling up to find out exactly what they need to do to reassure a resident that they are safe to exercise their rights. It's I guess it's really having a conversation, if that's possible, with the person to find out what their concerns are and really addressing each one if possible. I mean, sometimes that's not possible. Communication can be sometimes not clear, it can be difficult. So really getting to the bottom of something with communication can really help at the first point to be able to reassure a person on where they can go if they can't live here anymore, and what those changes might look like. You'll be able to move somewhere which is, you won't have that problem, you won't have this problem, but you might have a different setting. So really explaining through, each kind of phase of change, what a person might be looking at when they're either going to VCAT or looking at moving out or whatever the scenario might be, to really step by step go through that. I hope that answers that question.
Thank you. That's really great reflections and response. Thank you. It's Deb speaking. And I guess just to kind of, I really want to acknowledge that that we need to be working to kind of strengthen and protect, perfect and improve both the kind of current, like the exercise of kind of current protections, but really want to acknowledge the role of, your organisation, Bronwyn and AMIDA, of our colleague Naomi, Villamanta, and many others who are on the call today as well, in terms of, I guess, that constant kind of influencing work and engagement work that kind of happens behind the scenes often with your organisation and VCAT, with Consumer Affairs Victoria, etc. So there is a lot of private facing advocacy as well as public kind of systemic advocacy to really kind of push these kind of mainstream institutions, these kind of bodies like VCAT, etc., parts of government like Consumer Affairs Victoria, to do better and really, informing, I guess, about the scope of kind of resources that are needed to support kind of education, guidance, etc., as well as kind of like rolling up the sleeves and saying, well, it should look like this and you should adjust the information in this way to make sure it's accessible, meaningful, etc. So just really do want to acknowledge that, and that work continues, and we'll follow, continue to follow after today's session as well. Bronwyn, there was a clarifying question that's come in as well. So we were talking about community visitors earlier, and the question that had come from the audience was really kind of located in a CIL context, but your question, also your response to that question was a little bit more expansive as well, which was really helpful. The clarifying question that has kind of come to us is regarding community visitors. Someone was asking, Bronwyn, did you say that community visitors can visit other environments like SRS?
I believe so. I have heard of instances of that happening.
And I was just going to say, Bron, when it's Deb speaking, that we can work to kind of clarify that
Yes.
behind the scenes and come back to
Yeah, we can do.
the sector with that information. I just wanted to give people an update on Naomi. So our poor colleague Naomi has had her whole internet completely crash from where she's located today. So that's why you haven't seen Naomi come back on the screen. And I just want to acknowledge Naomi has done so much preparation for today and brings so much expertise to this conversation. I want to acknowledge that Bronwyn is doing an extraordinary and exemplary job in answering your questions. But what we will do is we're keeping a record of all the questions that come in, and we'll also augment the information that's been provided by our wonderful colleague Bronwyn today. We'll augment that with some additional follow-up complementary information from Naomi, kind of bringing to bear Villamanta's expertise as well. But thank you to Bronwyn for the great job that you're doing. And I know Naomi will be feeling quite devastated that she's not on the screen with us, but we will make sure that we're levering in Naomi and her colleagues at Villamanta, their incredible expertise alongside AMIDA's into this space. So more to come post event as well. Just wanted to, and I'm conscious of time, so we don't have a lot of time left, but I might just, Bronwyn, just without kind of question kind of on notice, is just thinking about that broader kind of reform environment and like, you know, AMIDA's kind of ambitions and aspirations around really lifting the bar on renters' rights for Victorians with disability. The Victorian Housing Statement that came out in September last year by the Victorian Government, massive agenda, lots of moving parts to it. One of the kind of key pillars is around renters' rights and, you know, to keep pushing kind of for rental fairness in this state. One of the, I guess, bits of detail in the housing statement was that the Victorian Government said that it would establish a new rental dispute body to help alleviate the wait times at VCAT. I'm just wondering, has AMIDA kind of started to give any thoughts, you know, to what you think that rental dispute body should be doing? Are there any kind of initial ideas or considerations for how you think that body could improve rental rights for people with disabilities? So bit of a question, not out of left field, but I guess looking at to our gaze around what's next in terms of realising rental fairness. Do you have any thoughts on that, Naomi, about what would be important from AMIDA's perspective about that new dispute resolution body?
Sure. So, you know, I really do hope that this body will step in perhaps before or during the VCAT process or even prior to that people can contact them for advice or to you know, have about the option of going to VCAT or not going to VCAT or whatever the scenario might be, that they're able to speak freely or communicate freely without that risk of retribution that we see a lot in the housing sector about who they're living with or who their rental provider might be, or worried that they won't be able to get housing or get supports coming in. You know, that there are a lot of concerns that I hope that this rental dispute body will, and we're happy to inform them as well, you know, from AMIDA's perspective about what we have seen across the board of what the needs in the community are. So I really do hope that that is something that will alleviate, I guess, the VCAT load, because I do know that they've gone up a lot in what they are now taking on as capacity, you know, their capacity for taking on VCAT matters. So yeah, if anything can happen with that process, we'll be very pleased about, and we're very happy to provide information, and we have quite a lot of systemic information that we can give them.
Thank you. It's Deb speaking again, and I think Bronwyn, something that like I'm really interested in as well is that obviously there's a lot of work to happen around the design of this new body. So ensuring that the expertise, the insights of people with disabilities, disability advocates, as well as self-advocates, are really like included in in a co-design process. And I think one of the things is that I'm sure thinking about like past kind of models during COVID that were like stood up in that kind of rental fairness space and kind of dispute resolution space as part of kind of the COVID emergency measures was that, the people involved in administering some of those COVID era schemes were just saying, people this should be a really accessible kind of forum to resolve disputes and affect fairness. And people shouldn't need, a legal advocate, for example, unless they want one to be able to kind of engage in that kind of process. And I guess what we would say is like stepping back from that is that that's kind of an ideal scenario, but it presupposes that there'll be kind of, the model will entail kind of enable procedural fairness, that there won't be kind of high barriers to having your voice heard in that process as well. So I think those early design conversations are going to be really, really important, that that people engaging with this body not only feel safe, but it's accessible and inclusive dispute resolution body as well, so that it really is helping affect justice. And I think when we talk about resolving disputes as well, it presupposes all the process involves, everyone kind of giving a little, and how do we ensure that people aren't trading off their fundamental kind of rights in terms of their housing as well. So I think a lot to think about with that kind of overlay of power imbalances that are experienced by people with disabilities, as we know from the evidence presented by the Disability Royal Commission. So the voices of the people on this call, as well as obviously you need to centre the lived experience of people with disabilities themselves, is going to be kind of central, I think, in that design piece.
I agree. That's really, really integral to what comes out of it.
Fantastic. Well, that brings us to the end of the Q&A. Please don't hop off the call just yet, because there's a few kind of key messages that I want to impart before we head off. So as I said, in a moment, a short survey will pop up on your screen. It will only take a few moments. It's not onerous. We really would appreciate like your responses to those questions so that we can kind of plan upcoming Renters' Rights Rundown events. Helps us collect insights from you. And one of the things I do want to mention, we've talked a few times about systemic advocacy as well. So as part of our rental fairness work, we will be producing, in collaboration with all of you, an insights paper that shares your expertise and lifts those up to bodies such as Consumer Affairs Victoria in terms of what's working well, what needs to be improved, and our ideas about what that improvement kind of looks like at a systemic level. So just want to mention that to you. More to come in that space over the coming months. A big thank you again to our wonderful colleague Bronwyn and the crew at AMIDA. Really appreciate your expertise. A big thank you to Naomi for Naomi's presentation and Naomi's participation in the first stages of the Q&A today. And Naomi will be lifting up Naomi's expertise post this event as well. Just really quickly want to thank and acknowledge the Department of Government Services and the Victorian Property Fund. These Renters' Rights Rundown events are made possible with their support. I want to thank all of you for attending, for making the time today to be part of this session, for all your questions that have come through. Really fantastic insights that we gather through the questions that you ask as well. And finally, I'd like to thank the VCOSS team. So Deb Pearce from our comms team, Noah Hurst and Ella Longhurst from our policy and advocacy team, as well as Melissa Hale from the Daru team in helping kind of prepare and implement this event today. And as I said, reminder, please take a few moments to complete the event survey when it pops up on your screen. A full transcript and captioned video recording of this event will be available in a few days, and we will send you the link to those resources. We'll chase up any questions we didn't get to today, as I mentioned, and Ella Longhurst will be in touch with you if you're interested in contributing insights to this paper that we're going to work on. If you want to contribute de-identified case studies, please be in touch with Ella, whose contact details are in the chat. And follow us on social media and sign up to our email alerts if you haven't already to learn about future events like this one. We'll continue to hold these regularly for the rest of the year. So thank you for joining us today, and I hope you have a great afternoon. Thanks, everyone. Bye.